Hello, I'm Alicia Bannon. I direct the Judiciary Program at the Brennan Center for Justice, and I'm thrilled to welcome you to a conversation with Professor Judith Resnik. Judith is the Arthur Liman Professor of Law at Yale Law School and the founding director of the Arthur Liman Center for Public Interest Law. Judith also sits on the advisory board for the Brennan Center's State Court Report, and she has been a wonderful partner to the Brennan Center's Judiciary and Justice programs for many years. Judith is a tremendous thinker and doer, and we'll be hearing today about her new book, Impermissible Punishments: How Prison Became a Problem for Democracy. It's a remarkable, ambitious, audacious book that tells a story across time and geography about the history of power and punishment within prisons. It traces the emergence of corrections as a profession and tells the story of individual prisoners who turned to courts and made what was at the time a remarkable ask: to be treated as people with rights. She also makes challenging arguments about tensions between our system of punishment and democratic governance. She argues that governments that set out to ruin individuals through punishment cannot simultaneously be committed to equality. I'll turn things over now to two of my colleagues from the Justice Program, L.B. Eisen and Hernandez Stroud, who will be interviewing Judith about her book.
Thank you so much for joining us, Professor Resnik. We wanted to start where the text begins, examining the origins of the prison system. In your book, you explore the history of punishment inside prisons across the globe. You study the rules that organize prisons, and some of the most fascinating aspects of this book detail the emergence of what you call the corrections profession that imposed, in your words, quote, radical restrictions on human movement, quote, as if doing so was normal. Reading from your book, you wrote that, quote, they discuss the utility and morality of whips, chains, dangling people from bars by their thumbs, diets of bread and water, and dark cells. They sought amelioration through classification and individualized treatment, championed lessening the use of prisons through proportionality in punishment, indeterminate sentences, conditional releases on probation and parole, and formation of patronage societies to assist discharged prisoners. Their playbook turned a variety of ad hoc practices into a system that made stringent control of human activities appear to be normal in and definitional of prisons. Can you talk about what prompted those conversations and debates?
First of all, I need to say thank you. It's terrific to be here and see thriving. I also just need to say this book is hot off the press. Its official publication date is actually Wednesday, October 1st. So it's a pre-press, and it has literally been in my hand not much more than a week and a half. And now, to get directly to your question, in Europe, God's authorized monarchs, Christianity authorized monarchs to impose punishment, however they wanted to do it, with no need for justification. So we all have a collective debt to the Enlightenment for saying, excuse me, you need to think before you punish, and you're supposed to have purposeful punishment. Beccaria in Italy, 1764, a marquis who published his volume on crimes and punishments anonymously because he thought he could get harmed because of it. And later it became what would today be an instant paperback, but a bestseller. And it was translated into many languages around Europe and into English. So his frontispiece, the first page, or the drawing, the frontispiece in his little monograph, is of an image of an icon of justice turning away from an executioner proffering 3 severed heads. I reproduce it here. The point of it is that he is one of the first to say, you can punish, but not like that. And he is objecting, in our terms, he'd be an abolitionist to capital punishment, as not proportionate that people in a social order have to limit some of their liberty, but they shouldn't have to limit it by giving up their lives. So he's a really interesting thinker. It's much thinner than me. a thinner volume that talks about of crimes and punishments and makes arguments that are drawn both as a utilitarian, what's useful, and also as a moral political philosopher, Montesquieu, et cetera, around what he has a phrase, consult your human heart, consult the human heart. And important today, which we'll have to talk about as we're haunted by the 1700s, as well as we can embrace parts of it, he was clear that as Barbary retreated, Barbary, his word, punishments would get less severe. Even though at the time, his description of okay punishments, back to your description, fetters, iron, caging, he was proposing alternatives to capital punishment that are, from many of our lights, awful, but in the context of a baseline, everybody works from baselines. What you know frames, psychologists will teach us, what we can imagine and understand. So his baseline was lots of people got killed. He has an archive, in his archive, there's like a list of a couple hundred capital punishments in Milan or something. I mean, capital punishment was common and frequent for minor level, alleged, proven or not crimes. And he's in rebellion against arbitrariness. Jeremy Bentham, famous in England, is against arbitrariness. So his whipping machine, because England whipped, flogged, birched, depending on your age. If you were under 18, you were birched. If you were over, you're flogged. The US Army and Navy flogged up until the 1850s. So whipping is very common, and Bentham thinks it's too arbitrary, but Bentham's whole point was that punishment was supposed to deter. He's a utilitarian, trying to be utilitarian through and through. What's going to be useful? Get rid of the incentive to have a crime, to do a crime, to be a criminal. How am I going to incentivize you? I'm going to scare the wits out of you. How am I going to scare the wits out of you? I'm going to build a prison called the Panopticon. It was not actually built. He wanted it built. He has a whole bunch of specs for it. And he wants an observation tower so we'll all look and see it. Foucault, sorry, famous French philosopher, is wrong about the privatization of punishment in terms of its conception in the Enlightenment. See it, be scared of it, and do not do the crime. Deterrence, deterrence, deterrence.
Excellent. Thank you so much. So I want to fast forward to the future a bit and take us to the United States. Your masterful book, which, as we've acknowledged, sweeps the centuries, excavates the transatlantic institutional scaffolding of punishment, documenting why undoing the harms of incarceration is difficult, even while changes are afoot. So the question is, what can American courts today, confronted with constitutional questions about prison conditions, learn from Enlightenment punishment theorists like Bentham? For example, in Plata against California, where the Supreme Court in 2011 upheld a court order that was established by a receiver requiring California to reduce overcrowding to protect incarcerated people's health and safety. Is there any evidence the majority there, led by Justice Kennedy, drew on Bentham or any other early punishment scholars in considering the purposes of punishment as it relates to the state's obligation?
Well, they all draw without necessarily citing, because they all have in their head in a stock phrase in the tens of hundreds of opinions and published decisions in US and other courts, but let's focus on the US, is you need to justify punishment with something they call legitimate penological purposes. Actually, a few of them, like there's Beccaria, he's cited in the Supreme Court, Payne versus Tennessee, about victim statements, request. I mean, they can be cited. They're capacious in their writing. They can be cited for a lot of propositions. Proportionality can be reason to do grievous things, including the death penalty for some justices. So the idea is that all of us have a notion that the state can't willy-nilly do whatever it wants. It's got to have a purpose. That's Enlightenment, with or without the citation. That's the relatively easy part. It's important to point out that for 250 years in the Enlightenment discourse about punishment, judges weren't players. Judges were not participants up until since the 1950s, and they weren't participants on either side of the Atlantic because prisoners were something called civilly dead, which is that you could not bring cases, you could not marry, you could not enter into contracts, you were enslaved, as some of the famous Enlightenment folks wrote about, to the state as part of your punishment. De Tocqueville and de Beaumont, two French minor noblemen who toured U.S. prisons in the 1830s to provide models to bring back to France, which had chaotic mélange and a crowded system. They wrote about how U.S. prisons were despotic, but they didn't then say, that's disgusting. They said, that's how you create discipline because prisoners are outside the circle of rights. And so here, in terms of the intervention, that's really important. And the frontispiece of my book is the handwritten petition by a man named Winston Talley in 1955. He writes, in 1965, sorry, he gets smuggled out of prison, his petition, and gets into federal court in the Eastern District of Arkansas and says, petition for a writ of prohibition to stop the whip, stop me from being whipped. So prisoners go to courts, federal and state, and they seek relief, arguing that they have rights. And their intellectual intervention as punishment theorists is to understand that their present matters. They're not saying, you can't punish me. They're not Bentham saying, abolish transportation to the colonies, abolish death penalty, says Beccaria. They're saying, you can punish me, but not like this, not by whipping. And they have an imagination. They're obviously super famous prisoners, Nelson Mandela being one of them in the United States, whether it's Martin Sostra or Caleb Washington. There are a variety of people, some affiliated with the Nation of Islam, some not, some highly politically engaged, and some people like Winston Talley. I've looked at Arkansas newspapers about him, and I can't figure, he doesn't seem to have any political affiliation whatsoever. It's Arkansas in 1960s civil rights era. He's a white man with a very low-level conviction being mercilessly whipped in the fields because he hasn't picked enough cucumber and okra, along with the other hundreds of people in what they call the Cummins and Tucker farms, which were the prisons in Arkansas. And he has the imagination that he's a person with rights and federal judges should stop the whip. And so part of my hope is that people will appreciate the political imagination and the philosophical sophistication to intervene in a longstanding discussion about punishment and to say the intervention is our present matters. Utilitarians look forward, retributivists look past, prisoners look at us now. We're people, we're rights holders. You can punish us, but not like this. And of course, the struggle for the last 70 years is what would it mean to have rights and be a prisoner? And can those two words coexist? But that's a real new idea. So the same way the paradigm shift, there shouldn't be slavery, or the paradigm shift, you should have purposeful punishment. This is another paradigm shift. And that's what gets federal and state and judges elsewhere starting to talk about, can you punish like this or that? So they're federal judges and other judges become part of the debate about permissible punishment because prisoners said, and then back to some of the incredibly impressive ones, the Republican appointee sitting in Arkansas is a judge named Henley. He gets the petition and he finds the fanciest lawyers in town who are head of the Bar Association, and he appoints them to represent Talley and two co-defendants, co-plaintiffs, co-petitioners. And he holds a hearing and he decides that you can whip because it's not cruel and unusual punishment in 1965 under the US Constitution, but only if it's limited to 10 lashes at the time, and there's a decision-making process that isn't just somebody whipping you in the field. To be fair to the time, none of us can flash back to 1960s Arkansas. Federal judges are trying to enforce desegregation orders, and the country is split about race. Henley is one of those judges who's not at the forefront of that, although he's part, but not at its, he's not one of the famous forefronters. He may well have thought that by insisting on some limits and making visible the practice through his opinion with a long opinion, he was going to either stop the whip or at least slow it, because there was a political fight in the state about whether you should whip or not and what whipping was about. And so he thought that the opinion could be contributing to that. And that just lets me make another point. Decisions about punishment are political, social decisions. Law gets involved in them, and law is both a contributor and the maker of the meaning of some of it. More recently, in the sense of law as courts and cases and judges and the US Constitution, both licensing and normalizing. But that's the relationship to the Enlightenment. Let me just add one more. The originalists, if you were serious about our history, which is derivative of England, all the guys I've been talking about are in a big debate about how should you punish. Nothing's frozen in time. They're all in the middle of fighting and trying to kick some punishments out and let some punishments in. And as I mentioned, Beccaria thinks it's going to be what we would now call evolving standards of decency. So if you wanted to take an analysis from the founding, it would be about a lot of contestation about how you punish rather than an idea that it's fixed.
So that's an interesting segue to another question that we're hoping to ask you. You said prisoners were, quote, civilly dead to the state. But then what happened in England early in the 20th century? You know, your book focuses, as we've spoken about, imprisonment, punishment, how the standards were created, have evolved, have changed across different countries. And what we spoke about and what you've been describing is this sense of sort of a utilitarian sense of purpose, of punishment, but it doesn't really focus on the people who are punished as people with rights. So how does the fight for prisoners' rights really begin? And you know, you trace what happened in England in the early 20th century, so perhaps that's the right place to start.
Well, so this is an interwoven narrative of the invention of a profession called corrections. So we started with a bunch of philosophers, theorists, activists, public intellectuals in today's nomenclature. And they're in gear, but they don't have scale. Bentham wants it. And I really invite on the originalist, read the contract from the Panopticon. It's dense and thick. Bentham wanted people to have food, and he was going to dock the governor, who he wanted to be, pay if anybody died. So if you took seriously, you could cite Brown v. Plata, could have cited him a lot for the propositions of well-being and take care and health. How do you scale up? You need institutional wherewithal. And so Foucault is correct in saying that these analyses rejecting shipping to the colonies and rejecting branding and rejecting physical murder of capital punishment, those lay the groundwork for saying, how can we punish? To which the answer was the penitentiary, the prison. And initially, it's prison men running institutions, mostly patronage positions. Sometimes it's philanthropists, charity. It's seen as social welfare. The creation of corrections is cheek to jowl with the creation of the social sciences, of sociology, anthropology, psychology, medicine, the medicalization of crime. It's a disease that we have to cure, so we need indeterminate sentences so that we can cure it, and we, the prison people, will figure this out. And over time, they develop into an infrastructure that creates institutional structures. We who are lawyers in the room may be members of the American Bar Association. There's something today called the American Correctional Association. Its roots are in the 1800s with entrepreneurial minister educators who say, let's all have a meeting in 1870, right after the Civil War, in Cincinnati, the first National Prison Congress, with a few hundred people, greeted by Rutherford B. Hayes, who went on to be the president and was then the governor of the state of Ohio. So first you get the scaling of the organization, convincing governments that they are specially expert in keeping people safe outside and keeping, in theory, people safe inside, and in discipline and transformation. Rehabilitation becomes a mantra for them, which is a post-1870s set of claims. It begins, there's a guy in France who's pushing it earlier. So there's this kind of idea. Corrections, think of the word. Hierarchy, authority, in name of change, not agency, not autonomy enablers or whatever else we want to call it, but instead corrections. Like many other parts of social ordering, want to scale up to international. So in 1872, the first International Penal Penitentiary Commission in London, that is then going to meet every 5 years in European capitals and once in the United States to talk about the norms of correction. Those meetings, social network theory comes next. Because once we're in a network and we're in this room together, we meet and we chat. Meanwhile, in England, something called the Howard League, in honor of John Howard, but not in any way as retributive as he is, has formed to do reform, because as soon as you get the invention of the penitentiary, there are social societies, religious, many of them saying, oh God, it's gross. Oh my, people are dying. It's not classified by sex or age. It's a violent environment. So these Howard League Society is part of the International Penal Penitentiary 1925 meeting in London, resuming after World War I. To think about the issue of prisons as if it's autonomous is to miss that the history of prisons and any of its reforms and prisoners' rights is embedded in the history of World War I and World War II. And World War I has grotesque behavior, plus it's embedded in human rights, because there are suffragettes in England being stuck in their quite awful prisons, white dresses or not. And therefore, a group of really interesting feminists in London in the 1920s are part of the Howard League, looking around the world at the terrible treatment in World War I of prisoners and making a claim that whether you're a political prisoner or not, fast forward to now and wish this were true, you should be treated identically and you should have rights. And they draft 7 rights up. They're very sophisticated political actors, and they run at the English government, which goes poo-poo, no. So they run at the League of Nations, which is founded in the 1920s and has crime on its agenda. And so now the International Penal Penitentiary Commission is nervous because there are competing organizations. So they take up this project to make standard minimum rules for the treatment of prisoners, which are promulgated for the first time in 1934. The Howard League draft said prisoners should have rights and prison can be torture. The International Penal Penitentiary Commission draft says neither of that. It does say, from a humanitarian and social point of view, we want good air, ventilation, decent conditions, and the like. And for discipline, you can use whipping. Corporal punishment is how they equate them. That's not the right equation, but that is how they equate it. And you can use dark cells, and you can use food deprivation while also wanting to ameliorate. That's 1934. Hitler takes Germany in 1933. This International Penal Penitentiary Commission, over the objection of the Howard League and Jews and some other people, meets in 1935 in Berlin, where they are greeted by, in the name of Hitler, the great new German procedure of mass trials and punishment. World War II, these groups limp along. And then after World War II, with the UN, just here last week in New York, the UN is formed in 1946, and 48 is the Universal Declaration of Human Rights. And this International Penal Penitentiary Commission, which had been cooperating with fascist countries, comes to an end at the US's behest, among others, where funding is refused. And the UN takes up the issue, and in 1955 promulgates its standard minimum rules for the treatment of prisoners. And it uses the words rights, and it uses the word dignity, and it says no whipping. It does say you can deprive food. The point here is to think about the relationship between plantation and concentration camp and prison, and the techniques of control that are parallel make the prison of the past unsustainable because of the world revulsion at the race subjugation of concentration camps interacting with the civil rights movement. And that's where rights get recognized in international documents. I have zero evidence on your citation that Winston Talley read any of that. There is evidence that that Martin Soster or some of the others are certainly involved with the international human rights movement. So there are some, but this claim for rights and status is a post-World War II legally recognized claim. Of course, there are prisoners before shouting to the rooftops that they should have rights, but here's where we enter law of this kind. There's law all along, but this kind of law.
Thank you. And I actually want to pick up on a strand of that. And before we sort of run out of time, I want to make sure that we talk about this anti-ruination principle. So, in the book, as you explore the interdependency of people in and out of prisons, and you argue that government committed to equality cannot set out to ruin people, and that leads you to the conclusion that many contemporary forms of punishment must end. You then lay the groundwork for the development of a new constraint on punishment, which you term the anti-ruination principle. And this view, you tell us, is why courts, quote, have ruled out a total lack of medical care, utter filth, and wanton violence. So I think we would want to know a little bit more about the anti-ruination principle. And then as a follow-up, thinking about how some of the thinkers thought about punishment, how do you expect it'll square as more and more judges, including some justices of the Supreme Court, ask not whether a punishment comports with standards of evolving decency, but instead whether a particular punishment violates what people in 1791 thought when the Eighth Amendment was adopted?
And I know we also have to cross the ocean again, but so step one, let me get to the end. Anybody who's litigating should be putting into the record Jeremy Bentham's panopticon contract. You want to know what a great thinker about prison thought? He thought that you had to provide healthcare and food. He worried, and this goes to an important facet. Bentham was really innovative in a lot of ways. He also caught human emotion. He talked about how some people begrudge giving prisoners anything. And any of us who want to think about changing the way people who are punished are treated have to appreciate that we can all be rightfully mad at people who've done egregious things to other people and done harm. So the begrudge part captures a real emotion of, goddamn, you did injury to someone. Bentham also said some people cry inhumanity at not giving people, because once you take people in your charge, you have an incredible burden of keeping them safe. If you're legalist like he is, if you're not sentenced to death, you got to keep them alive. If you're a utilitarian, make them work so that we don't have to pay for them. And if I'm really a utilitarian, tie the people who run the prisons incentives to the people who are beset by the people who run the prisons by making them co-venturers. So charge money for anybody who's injured or dies. He's got a plan. So the first is, if you're serious about originalism, you got a lot more historical work to do. I hope I'm being helpful. Bentham on incentives worried. He knew correctly that poor people, his words, would be more likely to be in prison. He didn't want to create incentives to have poor people want to be in prison because they're going to get food and housing and shelter. He says they should be less eligible than other people. On the other hand, you have to make them more eligible because you've taken away their capacity to get their own food and clothing. So this issue about understanding the relationship between how you treat people outside of prison and how you treat people inside of prison will bring me to fast jump for a moment to one of the big differences between post-World War II Europe and the United States. Post-World War II Europe, in many parts of Europe, generated social welfare programs, education, health care, sometimes housing. In the wake of devastation, more collective, community-based support for everybody. So when people in prison in some parts of Europe are given education or euros, as they were in the Luxembourg prison we were in, or other things, they're not getting what some people on the streets aren't getting. And so it's less annoying, begrudging, because everybody's being treated more the same. And so that gets to this normalization and in the European parlance, there's an idea that you should try to normalize and regularize as much as possible the street outside and the street inside. And that's great. And the regularization there is an idea. In the United States, back to our doctrine, it's the turn that is taken in the 1980s, not inevitable, but it depends on the composition of the court, is to use as the baseline their imagined non-empirical prison. And if that's how prison officials treat people, it's okay unless. So the baseline in the United States is, what are conditions in prison? And is this, in US constitutional parlance, atypical and a significant hardship, with prison as the baseline instead of with the streets as the baseline? So that's an important shift. If a person who's a co-equal being punished, you have to ensure that you respect their agency and capacity and you realize their abilities.
I'm going to combine a couple of questions because you cover a lot of ground in this book and way more than we can get through in an hour. So in the book, you point out, and we discussed this on the phone last week as well, that during the early 1970s, the US political and legal establishment put its weight behind three propositions. One, prisons were a disaster. This is coming from your book. Two, the focus ought to be on rehabilitation. And three, community-based alternatives were preferable to penitentiaries. And the backdrop to some of this, aspirational reform, another phrase from your book, includes the 1971 Attica Uprising, unrest at New Jersey's Rahway State Prison, California's San Quentin Penitentiary, in addition to what you call the avalanche of court litigation in the field of prison reform. So over the next decade, there was a slew of federal legislation introduced to reduce imprisonment's harms and improve conditions, along with a slate of model bills for states to improve conditions. But we know that that focus on prisoners' rights, although some have devoted their entire lives to this pursuit, was short-lived in the sense of consensus among US policymakers. So first question there is, what went wrong? And because we're having this discussion today at the Brennan Center, and our colleagues here know that the justice program here has been working for many years on a report highlighting how here in the United States, there are a number of innovative programs policies, correctional directors rolling up their sleeves, groups like Amend, who's here in the room today, working with correctional staff, incarcerated people on what you mentioned earlier, this idea of normalization, right? That one's life inside the prison walls should approximate one's life outside the prison walls as best as can possibly be given the circumstances. We've written about states that have embraced so-called dynamic security, which is a philosophy of how correctional officers engage with those who are incarcerated, a very different type of philosophy than command and control. Yet what we write about in this report is a few examples, right? When we sort of scoured the country, and we're highlighting them because they're innovative and we think many of these programs should be scaled and replicated. But the second question is, why has it been so difficult? I mean, this is a very existential question, but you've written quite an existential book. Why has it been so difficult in the United States post the 1970s to really embrace a philosophy of rights for incarcerated people and sort of this reimagining of what these places and spaces should look like, given the correctional officer crisis in this country, given the health risks of being incarcerated and working in these places? So again, sort of two-part question. We have this idea of the US in the 70s and, you know, this aspirational place we could have gone with our laws and our norms and our principles around running prisons and rights of incarcerated people. And how do we get from there to today? Again, very difficult to answer with the time we have left.
In 90 seconds. So first, part of what I'm trying to underscore is this is a transatlantic story. I'm not as global as I would aspire to be. And it's still a transatlantic story. It's also a public-private sector story. And that's also really important. And it's a bureaucratic story as well. So if I do a few, and it's also not like an inevitable story, because in fact, punishments have changed. At the moment, branding is not celebrated in both sides of the Atlantic. Transportation is not celebrated with the worrisome point that it looks like the US current president needs to be called out for efforts to revive that form, whether the person's convicted or not. And capital punishment is not common, except for the United States and a few other places. So efforts at control are not new, and they're not sui generis to the United States. And there are times when the US is seen as progressive, the same as Germany is seen as progressive in the 1920s. So it's not, I'm an anti-essentialist about the idea that, this is what America is, Lord knows, and this is what some other place is. So then the question is, what are the structures and ideologies and the like? And part of the effort to go back to the 1970s is to say, there was a model bill for states to adopt state by state prisoners' rights, a model bill for prisoners' rights. There was actually a law professor who said, we shouldn't do that. It should all be constitutional law. You think, what did you not understand about where we were and where we were going? But also how you make change. You don't want just some Supreme Court opining X. You want to have an embrace that is politically and socially secure. And going back to the 1970s, it's the Chamber of Commerce that says, let's get rid of what today we'd call the box, and not checking the box to say, have you been incarcerated or not? It was seen as a good thing for American capital. And there are still parts of, there's an organization called Right on Crime. The Koch brothers have been engaged in thinking about prison conditions. So the public-private sector needs to see the disabling practices of incarceration that take disproportionately Black men between the ages of 18 and 25 out of the education and labor markets and put them into places that are so dysfunctional. So could it have been different yet? And what were the politics in the United States that generated the presidents and governors And of course, we have to talk about the tax revolt. There's a great book by Michael Gratz about this. If you take away government funding and you can't tax, scrambling for those same 10 cents that is government tax dollars means it's in other parts of our lives. Alicia, we all talk about fines and fees and court financing and litigation financing. So this issue about government funding, government services are at stake. If you want government services, you've got to figure out a way how to finance them. And to finance them, you need general revenue. And for general revenue, you need willingness to tax for some things that you think are socially good. So that's a thumbnail. And so the tax, I mean, what are the differences in Europe? Tax structure, social welfare. The people I know who went and visited prisons in some of the European countries that are seen as model, at least I know of a couple staff people who came back and said to me, oh, there are pretty awful people who did really awful things there. It's not that they're nicer, i.e. there is terrible crime and there is also complicated settings. It's the physical environment and the effort to lower the harm. And the big part of the sell is you're making people who run prisons safer because you're lessening the violence and lessening the stress. And that goes to the joint venture. I would delete not just the word corrections, but the word rehabilitation and the word reentry. Everybody's we're all here. We may be in different settings, but we're all in the same place. And the question is, how can you figure out a way to shape places and communities we want to inhabit?